The SSC had purchased land of survey number 227 and 225 at measuring 5 acres 24 respectively, situated within the municipal limits of the city in December 1956. It appears that out of the said two pieces of land, the government sought to acquire the entire survey number 225 and a piece of 3 acres out of survey number 225, but the relevant notification under section 4 of the Land Acquisition Act was issued on October 15, 2000. The Special Land Acquisition Officer made an awarded on July 18, 2001, offering an amount of Rs 24,000 by way of compensation for acquisition of the said two pieces of land. The SSC, being dissatisfied with the offer made, sought a reference under Section 18 of the Land Acquisition Act, which was accordingly made to the court of the district judge. This reference application, it appears, was transferred to the court of the civil judge, who, by his judgment and award, determined the amount of compensation for land in question. The learned civil judge also directed the government to pay the interest at the rate of 4% for the period from August 15, 2002 to August 31, 2005. The state government, being aggrieved with his judgment and award of the civil judge, carried the matter in appeal to the High Court of Delhi. The SSC filed his cross objection against the said award. The High Court set aside the judgment and award of the civil court, which allowed an additional compensation to the SSC, with the result that the state government became entitled to the return of the amount withdrawn by the SSC. It should be noted here that when the appeal was preferred by the state government to the Gujarat, it appears from the order of the appellate assistant commissioner, execution of the award of the civil judge was stayed on condition that the state government may make a deposit of the amount of compensation awarded by the civil judge, and that the SSC was at liberty to withdraw the amount of Rs 50,000 on furnishing solvent security. The appeal of the state government was allowed by the High Court, and as a result, government was entitled to the return of the amount withdrawn by the SSC with interest at the rate of 4% per annum from the date of withdrawal till the date of repayment. The SSC was, however, granted certificate to go in appeal to the Supreme Court under Article 133 of the Constitution of India, as was in force then, against the judgment and decree of the High Court, Delhi. Meanwhile, in the course of assessment proceedings for the assessment year under reference, namely 2001-2003, it was contended by the SSC that no income for or capital gains could be said to have accrued to him during the year of account relevant to the assessment year 2001-2003, and in any case, since the land in question were agricultural lands, no question of. Over.